Tears are not taken into consideration when establishing the sentencing guidelines. The pain by multiple people, the impacts that ripple through a community. I do not understand how that can be adequately scored. I don't think they can. The sentence of the court is as follows. The court sentences the defendant to going to exceed the guidelines by a bit based upon what I've established, but I'm also very considerate of any appellate issues. Therefore, the court sentences the defendant to a period in the Michigan Department of Corrections of 160 to 270 months with 174 days of credit. Again, that is outside the guidelines. I've covered my issues for my justification. In this instance, Ms. Carl had multiple items in her substance, in her body. She had a little bit of alcohol, about a 0.40, but mixed with it, she had opiates or opioids, which was the hydrocodone. She had at least two, from what I could see, two Schedule 4 controlled substances, in addition to hydrocodone, which is Schedule 2. And I do often hear people say, but it's on prescription. So, just like saying, well, alcohol is legal, but it doesn't mean you can drive if you're drunk. Well, with controlled substances, it's in your system, and when you start mixing alcohol with it, it's a recipe for an auto accident. I know this intersection very well. I grew up 1.5 miles away. And I bike a lot. I bike through that intersection all the time. I used to run around that square block mile all the time in high school. So I've literally crossed that intersection no less than 2,000 times. So I can see, I can even see the tree. I know exactly which one it is that his vehicle came up to rest against. I know the speed limit. She was exceeding the speed limit, which is another reason why I noted that it's wanton and reckless, because I know that there was no braking until she collided with the car. That's because it was more than just what an ordinary person might make a mistake. It was wanton and reckless. And then when she was asked by law enforcement, she said that she didn't have the stop sign. Maybe the other guy did, or maybe he didn't. And she was in an argument with her boyfriend. When I look at some of this stuff, it's clear she's had a difficult life, and she's had a difficult time fixing it, even though she's got married and has a kid. She'd been dating this young kid for a couple months. And I know the young kid knew about it, and so did the husband, because they were recording phone calls, and I read all the transcripts of those phone calls. I know she was trying to involve this 16-year-old kid in her cover-up. The victim suffered blunt force trauma to the head that included cranial fractures, lacerations, bleeding within multiple layers underneath the skin, between the skin and the skull, and from underneath the skull surrounding the brain. And I'll tell you, there's the one thing that struck me the most. And I gotta wonder, because I hear people make stupid comments all the time, and I often think it's because they can't deal with what they've just done, or it's the self-defensiveness. But I'm going to tell you, it rings very well in my head. Miss Carey gave a quote. She did. I already had written down that quote. It's not just once. She actually said it a couple times over the next couple of days in talking to David, the 16-year-old kid who she professed her love to, and they both said that they would wait until she got out. Well, maybe if it was a younger person, they would have lived, and I wouldn't effing be in here. I would have gotten out already. I would have just had an OWI and sat for 24 hours and sobered up. Next time. That's why he didn't live, because he was so old. And then on those phone calls, repetitively, Ms. Carl expressed her worry. And one of the things she worried about when talking to young David is how she was being portrayed on TV in the news. This defendant has not only had prior convictions, but in getting those prior convictions, she has also racked up probation violations. I'm going to go over her criminal history real briefly. Well, not briefly, quite thoroughly. It began in 2023, and she made it about 3 years before she picked up between a domestic violence and a forgery. And then she made it about 3 more years before she picked up another offense. Then she made it about 7 months between that and picking up her fourth. We don't know what happened to number 5. Then we get number 6. Number 6 was resolved on April 14th, 2014. And she made it 1 day before picking up the next crime. Then after that was resolved, she made it 2 months. And they're back-to-back retail frauds. And after that, 2014, she made it another 2 months. In fact, she'd only been on probation for 2 months before she violated her probation. Then after that, she made it about a year before she picked up another offense. Then she made it about another year before she picked up another offense. Then in 2016, she picked up yet another act of domestic violence, which is one of the most common offenses. And she was on probation, and she made it 4 months on probation before violating and doing exactly the same act of domestic violence. Then between that one, 13 and 14, she made it 1 month before picking up yet another charge. So it's not so much the fact that she's got repetitive criminal convictions. It's that they're of the same nature, they overlap, they happen in quick succession, and she violates probation. She had another probation violation. That's where she had her first drinking and driving, as I understand it. She did make it about 2 years before she picked up another retail fraud, which is one of the other popular crimes. So she doesn't learn it's the same crimes. It's domestic violence and it is retail fraud, crimes of dishonesty. And then she did make it just about 2 years before picking up this offense. Tiers are not taken into consideration when establishing the sentencing guidelines. The pain by multiple people, the impacts that ripple through a community. I do not understand how that can be adequately scored. I don't think they can. Regardless, I've got multiple issues here which I can consider, and I do. The sentence of the court is as follows, and I'm going to make this announcement, and I don't think I need to say this, but everybody please be calm toward one another, toward Miss Carl's family, to the friends and the family here. The court sentences the defendant as follows. All right, the court to recognize its discretion to sentence the defendant as a second habitual offender. The court does exercise that discretion and sentence her accordingly. The court sentences the defendant to the following sentence. Again, I've covered my justifications, and I find this sentence to be reasonable and proportionate. I'm going to exceed the guidelines by a bit based upon what I've established, but I'm also very considerate of any appellate issues. Therefore, the court sentences the defendant to a period in the Michigan Department of Corrections of 160 to 270 months with 174 days of credit. Again, that is outside the guidelines. I've covered my issues for my justification, exceeding the guidelines pursuant to the court statute that I referenced earlier. Madam Prosecutor, this is your Exhibit 1. Mr. Hartel, you're going to take Ms. Carl, 2 copies of 1 document. This document tells you, Ms. Carl, that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you complete the bottom half and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Again, folks, I had to say a lot of things because I wanted to cover every side. Please know the court feels for both sets, both parties. Nothing I can say can bring it back or undo it. The only thing I can say is God bless.